Good afternoon. Today I want to consider two procedural matters in litigation which are in one sense banal, but on the other hand are of vital importance when conducting any litigation, large or small. And those two issues are when and under what circumstances you can amend an existing claim, what controls that, and secondly, on what basis can you get a claim summarily dismissed. And both these areas have been discussed in recent New South Wales Court of Appeal cases, which provide, one might say, principles that are pretty much universally applicable. And the first case I want to look at in this context is Wambo, W-A-M-B-O Coal Proprietary Limited, and Sumiseki, S-U-M-I-S-E-K-I Materials Company Limited, 2014, New South Wales CA 326, an important judgment of Justice Barrett that we'll come back to and look at in more detail because over about 250 paragraphs, Justice Barrett looks closely at the question of oppression and payment of dividends in a company context, which raises far more complex corporate questions that we won't discuss today. But in the course of his judgment there, His Honour also looked in detail at the way in which a court might permit an amendment of an existing claim in the context of a claim that was sought to be raised here with respect to a claim that Wambo's constitution wasn't properly amended. And His Honour referred to basic principles with respect to when an amendment will be allowed. And in that context, he referred back to his earlier decision in Kelly and Mina, K-E-L-L-Y-M-I-N-A, 2014, New South Wales Court of Appeal 9 at 45 to 48. And His Honour makes the point, paragraph 270 in Wambo, that any amendment application is governed by section 64 of the Civil Procedure Act 2005. And that section, in subsection 1, provides that at any stage of proceedings the court may order that any document in the proceedings be amended or that leave be granted to a party to amend any document in the proceedings. So we've got a broad power to amend at any stage of proceedings, pretty broad. Section 64 sub 2 then provides that subject to section 58, all necessary amendments are to be made for the purpose of determining the real questions raised by or otherwise depending on the proceedings, correcting any defect or error in the proceedings and avoiding multiplicity of proceedings. So we've got section 64 conditioned by section 58, and at trial, of course, the judge often makes discretionary decisions as to whether or not an amendment should be permitted, and that's a matter of practice and procedure, of course. And in terms of appellate intervention into that area, if you lose a trial, then you can only get judicial review on appeal according to the principles stated in House and the King, 1936 HCA 40, 55 CLR 499 at 505. And that means it's pretty hard to actually get appellate intervention unless the court is convinced, that the appellate court is convinced that the trial judge's decision is plainly erroneous. Now, section 58, of course, we've referred to, tells us that the judge is bound to have recourse to the dictates of justice, and in doing so they have regard to section 56. 56, of course, of the Civil Procedure Act contains the so-called overriding purpose, rules of court, which is designed to make justice quick, efficient and cheap if possible. And that legislation, of course, needs to be seen against the backdrop of the High Court's decision in Aon Risk Services in Australian National University in 2009 HCA 27, which is at 239 Commonwealth Law Reports 175. You recall, of course, prior to that decision, the High Court's decision, there was a fairly liberal use of power to amend, one might say, and provided that the party seeking the amendment was able to satisfy the problems as to costs and make sure the other party who was facing the amendment didn't have to pay out the costs, then you might amend at your leisure, so to speak. But of course, Justice Hayden, a lot of interesting judgments in that case. Justice Hayden, you've got one hand leisurely washing the other, I think he says. Modern litigation no longer permits you simply to go along and amend as you wish. That's because there's an overarching interest of justice in getting matters finished. Interes re publicae sit finis litium. You want to get rid of cases, and you can't just amend and keep matters running until kingdom come. And the basic principles, as Justice Barrett points out in Wambo, have been summarised by Justice Vickery in Victoria in a case called Namberry, N-A-M-B-E-R-R-Y, Craft Proprietary Limited, and Watson, 2011 VSC 136. And what are the basic principles? Well, they are these. You've got to ask yourself, first of all, whether there will be substantial delay caused by the amendment. Alright, is it going to cause immense delay? You're going to hold matters up for another 4, 5 or 6 months. If you do that, of course, you're pushing other litigants back in the queue, which isn't fair to anyone. Secondly, the extent of wasted costs that will be incurred. Any amendment, of course, will usually necessitate wasted costs because you'll have to then reconfigure your case. You'll have spent money looking at one aspect and that's no longer relevant. So you've now got to look at some other aspect. Thirdly, whether there's an irreparable element of unfair prejudice caused by the amendment, arising, for example, by inconvenience and stress caused to individuals or inordinate pressures placed upon corporations which cannot be adequately compensated for, whatever costs may be awarded. Well, point C, we know, of course, litigation is inherently stressful. No one likes to be in a court case. If you think back to the Wayne and the Commonwealth, part of the estoppel against the Commonwealth in the Wayne's case arose because the serviceman, the sailor there, couldn't be compensated in a sense for the stress of permitting the Commonwealth to suddenly plead a statute of limitations against him. So, in that sort of situation, one has to balance, I suppose, whether or not the costs are going to be adequate. And with individuals in particular, just having to go to court, prepare witness statements, see counsel, see solicitors is a very stressful thing. Lawsuits are very stressful. Then D, concerns of case management arising from a stage in the proceedings when the amendment is sought, including the fact that the time of the court is publicly funded and whether the grant of the amendment will result in inefficiencies arising from vacation or adjournment of trials. Alright, so of course Jim Allsop's had some things to say about this recently, trying to streamline the federal courts. We now want the system to purr along like a well-oiled motor mower. We don't want stops and starts in litigation, and of course because it costs a lot of money each day to have the court open and a judge sitting there, you've got to look at the public efficiency. Can you simply let someone stop and start at their leisure? Answer, probably not. Fourthly, whether or not the grant of the amendment will lessen public confidence in the judicial system. And finally, whether a satisfactory explanation has been given for seeking amendment at the stage when it is sought. Alright, so you've got a conspectus of issues there, all of which need to be addressed. And in this case, Justice Hammerschlag had refused the amendment, said it came too late, and the Court of Appeal upheld him. 273, as Justice Barrett notes. The Court of Appeal has emphasised more than once that the Civil Procedure Act makes substantive and important changes to the law, so the considerations of promptness and efficiency in the conduct of civil litigation are afforded a new and special importance, which may sometimes provoke a sense of injustice in a party who has failed to proceed with dispatch. Yeah, well, 274, you'll see it analyses the facts in detail, looks at the amendment and holds that Justice Hammerschlag, as he usually does, had correctly held that it had been raised at an inopportunely late stage of inquiry. Would have broadened the scope, taken it beyond the issues, etc., etc., etc. And His Honour at trial took into account all the relevant discretionary factors. So, being a discretionary matter, no alteration. So what does that mean generally? Well, it means that you've got to be pretty quick and careful to get amendments in if you're going to amend. Part of the problem, of course, is that often the weakness in your own case is only exposed as matters roll forward. And I suppose at some stage of the game, the other side might move to strike it out entirely. But the new regime in place since Aon, since 2009, means that we've really got to be on the alert all the time with a view to not permitting amendments at leisure. And very useful and interesting judgment, if one may say so, by Justice Barrett. Now that leads to the next point, which is striking out matters summarily, dismissing matters. And the Court of Appeal has recently covered that as well in a case called Simmons, SIMMONS, a New South Wales Trustee and Guardian, 2014, NSWCA 405. And in this case it's Justice Fabian Gleeson writing the judgment. In a case which one might say had been running on for a long, long time. Family dispute, we won't worry about the details, about ownership of land, and basically whether there was a possibility of pleading some sort of constructive trust to override the indefeasibility provisions of the Torrance Statute, etc., etc. And in this case there was an attempt to summarily dismiss the claim against the defendants, who were members of a family who inherited some property. And at paragraph 192, Justice Gleeson refers to principles recently reiterated by the Court of Appeal in O'Brien and Bank of Western Australia, which is the 2013 NSWCA 71. And in O'Brien's case, Justice McFarlane looked back to the High Court decision in Spencer and the Commonwealth, 2010 High Court of Australia 28, or 241 CLR 118, and in that case the High Court was considering the question of the Federal Court Act, section 31 capital A2, but it would appear from both this judgment and the earlier judgment that the statements made in the High Court decision are of general application in the context of a summary judgment application. And those are summarised in paragraph 192 by Justice Gleeson. And what are we going to look at? Well, he tells us first of all that on a summary judgment application, the real issue is whether there is an underlying cause of action or defence, not simply whether one is pleaded. So you've got to look through the position and see whether you can discern, I guess at the trial level, whether or not there's something, some live issue which is appropriate to agitate. And the critical question can be expressed as to whether there is more than a fanciful prospect of success. That's quoting Justices French and Gummo in Spencer's case, or whether the outcome is so certain that it would be an abusive process of the court to allow the action to go forward in the judgment of the plurality. Demonstration of the outcome is not required, demonstration is required, not an assessment of the prospects of its success. Alright, so you've got to show pretty much that the thing is going to be doomed to failure. And it follows from that the powers to summarily terminate proceedings, split infinitive there, to terminate proceedings summarily must be exercised with exceptional caution. Alright, so you've got to proceed very, very cautiously indeed. And in the earlier Court of Appeal case, Justice Ward expressed a similar sort of view. And in this case, the essential complaint was, at paragraph 194, that from the plaintiff that the primary judge failed to address whether there was an underlying cause of action, not simply whether one is pleaded. It was also said that the primary judge erred by failing to consider whether there is more than a fanciful prospect of success at trial, or that it was so certain to fail it would be an abusive process. Well, you can see a bit of attention here, of course, in the matter we just looked at in terms of amendment. Clearly, you might have more than a fanciful prospect of success, but if 25 years has passed and you haven't properly pleaded it, that must raise some issues as to whether or not you have got a viable case. I don't know how many bites of the cherry the pleader can be allowed. Well, paragraph 196 and following, Justice Gleeson summarises the principles in the context of this case. And he says that it's not in dispute, quoting General Steele, Sir Garfield Barwick's famous judgment, that great care must be exercised to ensure that under the guise of achieving expeditious finality, a plaintiff is not improperly deprived of his opportunity for trial of his cause by the appointed tribunal. That's the rule when I was a boy when I learned it. General Steele's and Commissioner for Railways, 112 CLR 125. At 1:30, Sir Garfield Barwick. About the only dictum I think of is it's still surviving, I think. Well, maybe it's not even surviving. Not much of his jurisprudence has lasted, but that case was followed, General Steele's was followed by the High Court in Agar, A-G-A-R and Hyde, 2000 HCA 41, 201 CLR 552, paragraph 57, where Justices Gaudron, McHugh, Gummo and Haynes said, ordinarily a party is not to be denied the opportunity to place his or her case before the court in the ordinary way, and after taking advantage of the usual interlocutory processes. Test to be applied has been expressed in various ways, but all of the verbal formulae which have been used are intended to describe a high degree of certainty about the ultimate outcome of the proceedings, if it were allowed to go to trial. And it only goes on to point out, but that's been pretty much the accepted issue since Agar's case. That's the way you could look at it. Another recent case, Justice Barrett in Shaw, SHAW in New South Wales, 2012 NSWCA 102, looking at the test. This was paragraph 32 as follows. The question is whether the claims in question are so obviously untenable or groundless that there is a high degree of certainty they will fail if allowed to go to trial, and whether this is one of the clearest of cases in which the court may accordingly intervene to prevent the claims being litigated. Alright, so the assessment has to be made taking the plaintiff's case at its highest, and the plaintiff for summary judgment or summary dismissal must accept the truth of all the allegations in the statement of claim and the ranges of meaning and assertion of fact which it's capable of bearing. In this case, there wasn't any particular issue as to whether or not you needed to refine the position in terms of the Civil Procedure Act, and of course that raises the point we've just discussed in terms of amendment, which is of course whether the statutory directives about the case management and overriding purpose might warrant striking out cases on less substantial grounds than those stated in General Steele. And we've got a bit of a hint of that in the more recent cases. You can see that if you're allowed to amend in some weak case that's not going to run forward, then of course you're breaching the rule with respect to amendment, and you're also defeating the overriding purpose. And in this case, the judge looked at all the facts in relation to constructive trust. Tricky area, of course, Barnes and Addy in all those cases. And at 211 His Honour concluded that the failure after ample opportunity to plead a reasonable cause of action leads to the conclusion that none exists, and therefore the plaintiff has no reasonable prospects of success. And he therefore concluded there was a high degree of certainty that the claim would fail if allowed to go to trial. Deficiencies in the proposed pleading relate not merely to deficiency of particulars, which might be cured by direction. The pleading deficiencies are of a fundamental kind, which are the consequence that no reasonable cause of action is disclosed. Even if allowance is made to treat some of the existing particulars as in substance, material facts, the proposed pleading does not plead the material facts which are required to establish a Barnes and Addy claim. Alright, well, you can see there a bit of a growth, I guess, in the court's willingness to intervene, both in terms of amendment, disallowing amendments, and also, I suppose, in relation to summary judgment, that's to say, summary dismissal. And as time goes by, I suspect we're going to see the court more and more exercising peremptory powers. It's an expensive business litigating, it's stressful, and the court seems to be taking the view now at the highest administrative level that perhaps you shouldn't be allowed to come constantly to the well, if you like, and try and draw up another bucket of water. You've got a few chances, maybe 2 or 3, but if you can't plead it within that time frame, then perhaps it's time it was dismissed, or perhaps your amendment was refused, both of which of course will have a similar consequence.